Ladies and gentlemen, so today let us look at a topic in contracts management. Arbitration alone, when you look at it, it has distinct features. The dispute is resolved through adjudication. The arbitrator is like a judge, like a court of law. He is a third person, but he is adjudicating. Unlike judges, the difference is that he is a private person who is appointed with the parties by their own choice. The judgment given by the arbitrator is final, binding on both parties. It's part of ADR, alternate dispute resolution, a mechanism given in the very body of the contract. The judgment is as good as a court decree, and the decree is executed or implemented accordingly. The Civil Procedure Code 1908, Section 89, speaks about settlement of disputes outside court. The 2002 amendment to the CPC 1908 is actually an effort at making litigation more effective and speedy, where it appears that there is a possibility of a settlement. The court can proactively again refer it to arbitration, conciliation, mediation, or a judicial settlement through lok adalat, etc. Where a court refers a dispute for an arbitration or conciliation, the provisions of the Arbitrations and Conciliation Act will apply. To Lok Adalat, Legal Services Authority Act 1987 will come into play. For mediation, the court shall effect a compromise between the parties and follow such procedure. The advantages of arbitration per se will be, it's a technical matter. The arbitrator is trained for that, he has special qualifications. It is faster than a court case, at least how it is designed to be. Saving in the costs, because both of them know who is the arbitrator and he is accessible. Courts, you do not sometimes get time for one listing with the mounting backlogs. Unwanted publicity can be avoided. Every day you need not go and step into the court of law dime a dozen times. Convenience of the parties is also possible. Time and place is agreed upon. The procedure by and large is simple and clear. The arbitrator works by consent of parties. Coming up further, there are benefits to the parties that arbitrator is as per choice. The issues to be arbitrated is chosen by the one who has asked for arbitration. There can be a choice as to the place of arbitration, procedural rules, time schedule. They are all falling part of some choice, some flexibility. The disadvantages, sometimes the arbitrator can be incompetent, sometimes he can be biased, and courts do encourage when there is malafide. Courts do encourage. Listen to the complaint. And courts have set aside many arbitrations, have come into and given judgments where a malafide is proved. Sometimes in arbitrations, because of the informality of procedure, they say that some injustice can come about. But it is not really a shut and close case, it is a conjecture. Arbitration can suffer from infirmities with regard to procedure or evidence, etc. So there is a need to be cautious, there is need to be a learned person in even monitoring, going through, extending support to an arbitration process and finally reaching the logical conclusion. Ladies and gentlemen, my effort was to highlight the reasons of disputes in contracts and the general alternative dispute resolution mechanisms that are in hand. There are number of factors that will decide which path you choose. So Allah is in wonderland. Allah says, we know we have to go, but we know where we should go. Thank you.